Quite a lot of companies from Kazakhstan have business relations with organizations from other countries. When concluding a contract, the parties agree on the place where the dispute will be resolved. One such option is the Arbitration Institute of the Stockholm Chamber of Commerce, which we will talk about in this video. The Arbitration Institute of the Stockholm Chamber of Commerce is a regular commercial arbitration. In other words, a non-state court that resolves economic disputes between companies from different countries. The arbitration is located at the Stockholm Chamber of Commerce, and international arbitration decisions are enforced in more than 170 countries. Firstly, in arbitration, the arbitrators consider the merit of the case. Here is a wide list of evidence. For example, interviewing witnesses or other methods are often used. The main goal is to resolve the dispute, not to consider theoretical legal issues. Another important advantage is that the parties themselves can choose arbitrators to consider the dispute. For example, the parties can choose a specialist in international contract for the supply of goods with knowledge of English. The parties can choose the law under which the case will be considered. This may be the national law of country or international rules, for example Incoterms 2000. It is also not necessary to attend the meeting of the Stockholm arbitration. It could be online or offline meeting, depending on choice of the parties. All disputes in the Stockholm commercial arbitration are confidential. Decisions cannot be published, and the result is known only by the parties to the international dispute. Stockholm arbitration has several types of procedure, regular and accelerated. There are several differences in this procedure. First, the number of motions that parties can file is limited. Second, deadlines are shorter. Third, the dispute is considered by a sole arbitrator, and oral hearings are held only at the request of one of the parties. There is also an emergency procedure. The parties send documents, an arbitrator is selected within 24 hours and within 5 days to resolve the dispute. An arbitration clause means that the counterparties have chosen their place, language, and rules for the consideration of the dispute. In these documents, parties should choose: first, the place of arbitration; second, the language of the arbitration proceedings; and third, the applicable law. It is worth remembering that arbitration is more expensive than going to the state court. So, for example, if the amount of the claim is 100,000 euros, then the legal cost will be 21,000, of which 5,000 are the administrative organizational fee and 12,000 the arbitrator's fee. However, there is one plus. There is a compensation rule. It's written in the official rules of the Stockholm arbitration. This means that the party that wins the dispute will receive compensation for the arbitration and administrative fees. In your claim, you need to describe your situation. It is worth paying special attention to the evidence. This is what confirms your position, why you are right. This may include context, checks, agreements, correspondence, and oral evidence, such as witnesses. The arbitration tribunal will also determine the deadline for filing a statement of claim and response for the defendant. In the statement of claim, it is important to write: first, statement of specific requirements; second, a statement of the fact and circumstances referred to by the plaintiff, and evidence referred to by the plaintiff. After consultation with the parties, the arbitral tribunal must determine the date and time of the hearings and location of hearings. It could be online or offline. After the hearing, the arbitration tribunal will make a decision on your case. This will be done no later than 6 months from the date of the transfer to the case to the arbitrational tribunal. Another advantage of applying to the Stockholm arbitration is that the parties will immediately receive a decision. If the counterparty decided to conclude a settlement agreement, then it is better to do as a decision of the Stockholm arbitration, because then it may need to legalize, for example in Kazakhstan. Follow our advice, ask for help to specialists, and you will succeed.